Hello, and welcome to topic 3, a topic that is focused on the issue of federalism. And this is the first lecture of 2 lectures for this week. What are we going to be looking at in this lecture? Well, the first thing that we're going to look at is we are going to talk about dividing power within a country. We started that conversation a little bit last week when we were talking about what confederalism is, but we'll continue that today. And then we'll talk about the way in which federalism is found in the Constitution. As we know, federalism is dividing power between a national government and state governments. And the way that that power is divided is found in the Constitution. So we'll look at where we find that. So let's go ahead and get started. Okay, the first thing I want to talk about is federalism. On the surface, when you're reading this chapter this week, you might be thinking federalism, ho hum, how dull, the division of power between the national and state governments. Well, actually nothing could be farther from the truth. Federalism is actually quite exciting because at the heart of federalism is the question of who has the authority to do something, who has the power to do something. Is it the federal government? Or is it the state government? And that is a pretty hot topic. It has been since our founding, but that continues today. And some of these pictures on this slide just sort of show you why federalism is a hot topic. On the left-hand corner there, you have, what is that, a Buckeye leaf? Nope, that's a marijuana leaf. And marijuana, as you saw at the beginning of your chapter, the issue of that some states have legalized marijuana, both for medical and recreational use. But as we know, marijuana is still considered a controlled substance. So who should decide? Should that be a decision that should be left to the states, or does the federal law trump the state laws because the federal law says that it is a controlled substance? The answer is federal law does trump state laws. But I guess the question is that a matter that should be left to the states? On the other side, you see a picture of two couples getting married in a same-sex marriage relationship. For a long time, the question about whether or not people should be allowed to be married who are of the same sex was left to the states. But in 2015, the Supreme Court stepped in and said no, that's a guaranteed constitutional right. Well, should it be? Is that a national policy that we should have, or a national guaranteed right, or is it something that should be left to the states? We've got issues about gun laws and the role that the federal government, do they have the authority to have national sorts of policies on guns? We have questions about the national government's authority to regulate the kinds of energy that we use, having national standards regarding climate emissions or carbon emissions, the kinds of light bulbs that you can use, or is that something that is beyond the power of the national government? And here's an example that just recently about Medicaid. When the Affordable Care Act came to the Supreme Court, the question was, could the national government force states to expand Medicaid? And the answer was no. The national government didn't have that authority. So on the surface, federalism might seem kind of boring, but actually when you drill down, it's one of the more fascinating topics that you'll be studying about this semester. Okay, so let's look at the different ways that power is divided within a country. As we know, there are different ways for that power to be divided. One is according to what's known as the unitary system for dividing power. The other that we talked about last class period is the confederal system for dividing power. And the kind of power sharing relationship that we have in the United States is federal. The United States Constitution creates a federal system. So let's go ahead and look at these different models. Okay, so the unitary system is almost the polar opposite of the confederal system. As you can see from the diagram there, that it is the national government that has all of the power. The national government is sovereign. And so in other words, the national government makes all of the policies. They make policy about healthcare, about education, about criminal law, etc. And then once that policy is set, then it's just basically the role of the states or the provinces or whatever those subunits of government are called to put those national policies into action. So power is delegated from the national to the subnational units of government. And power is very centralized in a unitary system. Now, you might want to ask yourself, what are the benefits and what are some of the drawbacks of the unitary system? One benefit is that it makes policy more uniform throughout the country. That it doesn't matter where you live in the country or what province or state that you live in. Like when it comes to educational policy, we know that all of the students in the nation are getting a similar educational experience and curriculum. When it comes to crime policies, that when, regardless of where you live, if you commit a crime, then everybody gets that a similar penalty. We see that that's not the case in the United States. In the United States, you could commit a heinous murder in one state, and the biggest punishment you could get would be life imprisonment without the possibility of parole. But you commit the exact same crime in another state and you can receive the death penalty. And so there's something to be said about that unified policy. There's a downside to that too, and so maybe think about what some of those downsides are. One of the downsides is if the national policy is bad, then everybody in that country is subject to it. It also doesn't allow for a diverse policy as it reflects a more diverse country. Unitary system works best in countries that are relatively homogenous. But when you have a lot of regional and ethnic diversity within a country, the unitary system does not work as well. We don't have to spend a lot of time talking about the confederal system because we did that last class period. As we know, in a confederal system, the states are the ones that are sovereign. They're the ones who have all the power. And they divvy that power, they delegate that power down to the national government. And the national government is seen as more of a servant of the states. States are seen as equal partners in decision making and kind of like a league of friendship. We know what the upsides of that are and the downsides. We talked about that last class period. The upside is that it diffuses power. So if you're worried about power being abused by a national government, then this is the way to go. On the flip side of that, as we know, why the Articles of Confederation was so short-lived is because it really didn't, you need to have a somewhat vibrant national government in order to keep this nation together. And the downside of confederalism is that in theory it's a league of friendship, but oftentimes those states end up competing with each other. The kind of system that we have in the United States is known as a federal system. It is a power sharing relationship, and power is divided between the national and the state governments, and power is allocated constitutionally. If you want to know what the national government can do, you'll look in the Constitution. If you know what states can do, you'll look in the Constitution. And so that the powers are defined in the Constitution. And as we're going to see, that each level possesses an amount of autonomy. There are certain things that only the national government can do, such as coin money, declare war, and there are only things that the state governments can do, mostly having to do with these coercive powers known as police powers that we'll talk about in a little bit. I want you to keep in mind that look at that relationship between the state and local governments. As you know from reading in the text, local governments are not mentioned in the Constitution. The only types of governments that are mentioned are national government and state governments. Local governments do not appear. That's because local governments have a unitary relationship to their states. Local governments, municipalities, townships, towns are created by the state, and that basically the cities have very limited kind of autonomy to implement the kinds of policies that they see fit that may not be implemented by the state. And so there's a unitary relationship between state and local governments. And make sure to read in your textbook about this thing called home rule that allows some cities to have a little bit more autonomy. Keep in mind that the reason the founders chose the federal system was because it was seen as another part of the architecture of democracy. That remember that the founders wanted to make sure that government worked, whether angels were at the helm or less than angels at the helm. And so they instituted the separation of powers, they instituted the checks and balances, they also instituted federalism because it divides power between the states and the national governments, and then a natural competition develops between the national government and the states. When the national government tries to step in the state powers, the states push back and vice versa. And so this was intentionally created as a part of the broader project to keep power in check. You know how you sometimes come across people who are like, I hate government, or I don't trust government. Well, the next time you come across people like that, maybe ask them, hey, which government are you talking about? So as you can see from this slide, in the United States, it's not just government, but it's really many governments because of federalism. And this just basically shows you some images of the many different kinds of governments you'll come across in your lifetime. In the United States, we have over 90,000 types of government that we have in the United States. In the bottom right-hand corner, that's a picture of the U.S. Senate floor, and they represent the national government, one national government. On the left-hand side, you'll see that that is the rotunda of the state legislature in Madison. It's beautiful. If you've never been, go and take a look, although I think many of you take field trips there in your secondary school years. And that represents the state governments. And there are 50 state governments, obviously, in the United States because there are 50 states and each of them have their own constitution and make their own laws. And then in the top left and right, you see that on the left-hand side is the Waukesha City Hall, city government. And on the right-hand side is the beautiful building of the Milwaukee City Hall. If you've never been there, check it out. It's an architectural wonder. And so just some images that show you all the many different governments that we have, even represented just here in Wisconsin. All right, so let's take a look at the powers of the national government first. The powers of the national government are referred to as expressed powers. And what expressed powers means these are the powers that are actually written in the Constitution. They are enumerated in the Constitution. And these are the powers that are exclusive to the national government. That for the most part, these expressed enumerated powers are only things that the national government can do. States cannot do these things. And so where we find these expressed powers are in Article 1, Section 8. And here are some examples of expressed powers. Only the national government can coin money, declare war, regulate commerce between the states and with other nations, raise a national army, etc. You will learn in your textbook that there are some powers that are written in Article 1, Section 8 that are deemed concurrent powers, such as the power to tax. But for the most part, Article 1, Section 8, these powers are exclusive to the national government. Now, beyond the express powers, there are other powers that the national government has. And these are, in your textbook, referred to as implied powers, okay? And so Article 1, Section 8 tells us, enumerates the powers of Congress. But what implied powers are the powers that are derived from the express powers, but aren't explicitly stated in the Constitution. And these implied powers come from, at the very end of Article 1, Section 8, there's this clause, it's called the necessary and proper clause. It's also referred to as the elastic clause. And that's because the necessary and proper clause can stretch an expressed power in order to grant the national government a different kind of power, but one that is related to the enumerated powers in Article 1, Section 8. The necessary and proper clause reads that Congress has the power to make all laws which shall be necessary and proper for carrying into execution the foregoing powers, the ones that were just listed, and all other powers vested by this Constitution in the government of the United States or in any department or officer thereof. Okay? And that's the necessary and proper clause. In other words, that federal government can stretch one of its expressed powers to create a law that isn't exactly related, specifically enumerated in the Constitution. Let me give you some concrete examples to make this easier to understand. So, right near after when our Constitution was ratified, the national government passed a law allowing for the establishment of national banks. And the national government put those banks into states and told states that they needed to basically run those national banks. And the states cried foul. They're like, hey, wait a second. There's nothing in Article 1, Section 8 that says that you have the power to create a national bank. The question went to the Supreme Court. What the Supreme Court said was that, yeah, you're right. However, the United States government has the power to coin money and to regulate commerce between the states and other countries. And if you take those powers and stretch it, it gives the national government the authority to create and establish a national bank via the necessary and proper clause. A more contemporary example of that is the Affordable Care Act and the use of the Congress's use of the taxing authority. In the Affordable Care Act, which was a national law, as you know, there was a penalty that you would have to pay if you didn't have health insurance. And that when that law was passed, people screamed foul. And they said, look, Congress doesn't have the authority to penalize somebody for not having health insurance. That question went to the Supreme Court, and the Chief Justice Roberts wrote the ruling in that opinion. And he says, yes, they do. Why? Because Congress has the power taxing authority, and that a penalty for not having health insurance is basically just a tax. And so you can take the taxing authority that Congress has and you can stretch that to create a penalty for not having health insurance. And that's absolutely constitutional because of the necessary and proper clause. All right, so what about the powers that the state governments get? Well, the powers of the state are known as reserved power. Why is it called reserved power? Well, it is called reserved power because of the 10th Amendment. And that's the text of the short 10th Amendment. It says the powers not delegated to the United States by the Constitution nor prohibited by it to the states are reserved to the states respectively or to the people. Now, when the Constitution was being ratified, the states got really nervous. They looked at Article 1, Section 8 and the necessary and proper clause, and they were like, wait a second. You said this is a power sharing relationship between the national government and the state governments. But there's nothing in the Constitution that tells us what states can do. And not only that, but you got this long list of things that the national government can do. And then you've got this elastic clause that can actually sort of magnify those powers. And they were like, you know what? We're not going to ratify this Constitution unless you amend this Constitution in order to be more specific about what powers the states get. And they agreed, and one of the first acts of the new Congress was to amend the Constitution to include the first 10 amendments, known as the Bill of Rights, and the 10th Amendment is a part of that. And so the reserve powers are these powers that are just basically left to the states. And they are oftentimes known as police powers. So that what's generally reserved to the states are these coercive powers that the state has to regulate the behavior of the people that live in the states. That's not seen as something that the national government should do for the most part, right? Even criminal law at the national level, which is regulating behavior, the federal government criminal law has to be related to interstate commerce, right? Crimes that take place between states, not within states. That's reserved to the states. And so, as you'll read in your textbook, reserve powers include things such as health regulations, public health laws, safety laws, crime and criminal code, which is related to safety, anything having to do with morals, that might have to do with marriage, might have to do with adoption laws, licensure for certain kinds of professions, etc. And so these are the powers that are reserved to the states, and those are the powers that the states have. They're not defined, and so it does create this space in the Constitution for a lot of power for the states to have in a regulatory capacity. All right, I will leave it to you to take a look at Article 4, which lists the states' obligations to each other. In that, you'll find the full faith and credit clause. That is the expectations that states will honor the public acts of other states. That's Article 4, Section 1, that basically states recognize restraining orders between states. They recognize marriage between states. They recognize driver's license as you're traveling through states. I'll let you read about that. I'll also let you read about the comity clause, which is basically saying that states can't can't discriminate against someone from another state within their state. And so that's Article 4, Section 2. And I will let you read about that in the textbook. All right, that's it for this lecture. In the next lecture, we're going to be taking a look at the changing relationship between the national and state government, looking at the different eras of federalism. Thanks a lot for listening. I appreciate it.